We went through the terminations, the termination for lack of appropriation, termination for convenience, termination for default, anticipatory default, void, to a degree voidable, even though voidable is during the what we call the procure stage. And now we're, if you will, on the home stretch. We obviously have covered a whole lot of material in 5 days. We've covered 785 slides, 784. Which is a lot of material, and so we have a few new concepts today, but a lot of it is just kind of like wrapping up, and the focus of today is closeout, because it's the emphasis is on managing a contract from the first day to the last day to get what we're paying for the full duration from the first day to the last day. And lots of times, as we said on the first day, there's a tendency to kind of slack off during the course of a long-term contract, that you may not be as diligent to seek the vendor to perform in the third year or the last 6 months or something like that. So the focus now is to keep the pressure on, get what we pay for, and in particular, before we make final payment, get everything we are entitled to get. So that's where we're going. So now we're talking about, we have a contract that is set to expire, but we have a renewal option. And we have mentioned this before, but one of the decisions is, if you have a renewal option, do you exercise it? And generally what we recommend is a single individual, such as the contract manager, does not make that decision, him or herself. That typically you get other people involved, what we call the contract management team, to discuss the things that we mentioned 1 or 2 days ago in terms of, is the contract still delivering what it was that you entered into the contract to do? Are you still satisfied that you want to continue? Is the vendor performing so that you want to continue with that particular vendor? And the reason why we emphasize the 6 months or more is, as we said, I think 2 days ago, number one, you can decide to do a reprocurement while you still have the renewal option as a viable alternative, and see whether you get better prices under a new procurement, and then choose whichever one is more advantageous. And you obviously have to start long enough in advance to make decisions as to what to do. If the decision is not to reprocure, it's just not to renew, period, you're going to do a reprocurement. If there's something, as we went through the various scenarios where you might want to exercise an option but with modifications, that there's things about the contract that you would like to change, so you don't want to renew it exactly as is. You do want to renew it if the vendor will do certain things via a modification. So you want to discuss this and decide whether you want to offer a modification. So basically, as a general rule, and you'll have to decide whether you want this to be even longer, at least 6 months before a current contract expires, then reconvene the team to decide whether to exercise the renewal option, to do a follow-up contract, and obviously if it's a continuing service, you're going to do a follow-up procurement or exercise the option, but sometimes it isn't a certainty whether you're going to continue with a particular contract. So you need to make that decision. If you have no renewal options, then you're definitely either going to do a new procurement, or maybe you decide not to have the service in the future, or maybe you decide to do it with state personnel or an interagency agreement or something of that nature. Let's see, whether circumstances in lieu of exercising. All right, so that's that. If it is determined that there will be a follow-up contract to continue the services being provided by the current contractor, an assessment should be made of what worked and what didn't work under the current contract. And this is something, as we went through the what would you do type exercises, usually what we said was, okay, what is the current situation? What would you do currently? But then what would you do in the future to try to avoid this same situation from happening again, where you have to take time and effort to make a decision of what to do, and you may not have the full array of options that you would like in the future. And so you try to make sure that you improve the contract. It's the concept of continuous quality improvement. There's always something you can do better the next time. And so you focus on what you liked about the contract, what you want to have continued when you go into a new procurement, or what do you want to change. Let's see, and that's what we're talking about here. If there are no available renewal options aside from deciding about a follow-up contract 3 to 6 months before the current contract ends, the project management team should focus on closing out the current contract. So you're on two parallel tracks. Even if you are going to do a follow-up procurement, even if you're going to, if you're going to do a follow-up procurement, then you are focusing on two things. You are in the procure stage of that follow-up contract where you're planning for the specifications, procuring it, etc. But at the same time, you should be planning on the current contract, closing that out so you have full performance under the current contract while you're in the activity for the successor contract. It is important to systematically close out the contract to ensure that the agency has gotten, or all indications are that it will obtain, all that the contractor is or was to provide. So you're going to make sure, as you start to close out, that's the emphasis of closeout, that you don't leave things on the table, that you're not continuing to pay the vendor, but you're not getting the things they're supposed to do. And since there are often what we call run-out provisions, and we're going to discuss those shortly, that you want to make sure the vendor is, number one, aware of them, which they certainly should be, but the indications are that they intend to comply with them and give them to you. Because sometimes these run-out provisions are something we pay for, and sometimes we don't. And so we still expect the vendor to do what they're supposed to do, even if we don't pay extra money for these run-out provisions. Let's see, timing, effective plan, lessons learned. I've talked about this, lessons learned, orderly this is another aspect. If there's a follow-up contract, obviously, you want to have a smooth transition from one to the other. So it's what we call seamless, transparent, that you go from one to the other without missing a beat. So that's part of what you're doing at this stage. A solicitation or contract requirement should be that the contractor must submit a formal contract closeout plan at a certain time prior to the end of the contract. So when we say this is a requirement, when you do the specifications and award the contract to begin with, this is something we are recommending that you have in that procurement. So it says that at the, let's say, 3-month mark before the end of the contract, the vendor is supposed to give you a specific plan for how they are going to properly close out the contract, assuring that all deliverables have been met, and they're going to tell you what they're going to do, when they're going to do it, who's going to be involved, so that you can look at it and you can be assured that the vendor at least has a plan for a proper closeout, and then the only issue is implementing the plan. But you want to make sure they have the plan. When each step will be taken, the involved personnel. And even if you don't have this to begin with, as we've said many times, over the course of the contract, you can try and have a modification, which hopefully would be a no-cost modification, to have the vendor give you this type of plan so that you're getting that full performance to the last day. It should be required, as we've said, for any of the plans or any of the draft reports. They go to the agency reviews them, the agency has the right to direct the vendor to change the plan, to make corrections to it, to resubmit it, and to get final approval. They just don't give it to you and say, that's it, that's what we're doing. And we should be conscientious in reviewing the plan and requiring changes if necessary for evaluated contracts, competitive sealed proposals, and in particular, that typically this is something you can ask them to provide a draft of this closeout plan in their proposal, in their technical proposal submission, so you will have some idea, even before you award the contract, of the conscientiousness of the vendor, the detail that they have in closeout, and the indication that they at least have intent at that point in time to properly perform to the last day of the contract. And sometimes these things, the startup plan and various other plans, are very important in making this selection of a vendor for an evaluated contract. And this is one of the reasons you might choose to do competitive sealed proposals if you have a major contract, You'll want to see these aspects so that you are selecting a vendor that seems to have the capability and the intent to perform. All right, contract closure checklist. We're probably going to go through each of these, so I won't detail them now, but these are the things that you will focus on. These are the things we're going to focus on right now. Contract closure checklist. We've talked about a contract performance checklist. Now here's another checklist specifically related to closeout, so that you make sure you know each step that's supposed to be done, when this vendor is supposed to do it. It is best to create the initial version of the contract closure checklist as part of the contract management plan and revise it when the contract management team meets to begin implementing the contract closure process. So a specific plan for closeout. Now we're going through that chart we had the slide 2 slides ago about the specific aspects you're going to focus on. Have all the deliverables been received? Very obviously, if you have your contract compliance checklist and you've listed everything the vendor is supposed to do, has the vendor done everything to this point in time, or at least they have very good indications that they are going to have everything completed by the required time? If they don't, then you still, hopefully you've done some remediation issue to this point. If you haven't, you need to do it to this time. And the thing to remind the vendor is final payment is not going to be made until we have everything we're supposed to have. And like we said many times, vendors want their money. And so if you say, by the way, here's something you haven't done, you're supposed to do it by this point in time, either you've already missed it or you're supposed to do it a month from now and all indication are you won't make it, just be reminded that we're going to hold up final payment until we get all the deliverables that we have contracted for. And if you don't give it, something's going to get deducted, you're not going to get paid for it. And whether that'll be sufficient, hopefully it will. Maybe you'll have the bond issue, maybe you'll have liquidated damages, but we'll have to see. But at the very least, you remind them of the requirement for deliverables. And these are the exceptions. Run-out provisions are things that are going to survive the contract. So in effect, the contract continues for one or more certain provisions, even though all other aspects are done. And the most common run-out provisions are warranty or maintenance. Obviously, if you have a maintenance for 2 years after you have the delivery of something, you might have that part of the contract if you're paying for it, or you might just say this is something that if something goes wrong, we have the right to call you back in for up to 2 years. And it's a run-out, something that survives the contract itself. Things like they're required to keep records. They're required to keep records for 3 years after final payment. So you'll remind them of that. That's a run-out provision. There may be other things, such as if there is a court case or a lawsuit, they may have to come back in and give expert testimony related to their work under the contract that defends the issue from the state's perspective. So that's a run-out provision. There might be a number of them. So except for run-out provisions, which are going to be after the contract's over, you make sure all the deliverables are received before final payment. And whatever is necessary to validate if the deliverables done, then you make sure that is done to validate whether you've gotten it to the proper standard. So again, you know whether to pay. Intellectual property, and we have a nice little example on this one. Has it been resolved which items, documents, procedure, etc. that the contractor used where, and these are important terms, works for hire. A work for hire means we're paying them to do what it is that they're producing. And if we're paying them to do it, we own the work that they have done. And so that's frequently sometimes an issue when you're in a award stage as to what is, and more particularly as you're going through the contract, what is something that basically we're paying for the vendor to create versus something that the vendor already had before they came to work on our contract and is just using something they own. And this is a frequent area of contention of vendors taking exceptions to the state's terms and conditions. Like lots of times they will say they will not agree to, I'm trying to remember, the indemnification or some other aspects because they're saying, well, we won't agree to this because we won't agree that, for instance, the disclosure of the Public Information Act, things of this nature, they might say, we will not disclose something that we already brought to the table, that we already own. So a work for hire is a term of art that the lawyers understand, and you need to kind of figure out and hopefully work through with the vendor which aspects you're paying for so you will own versus which aspects you really haven't paid for, that even if they use it, you're just getting the benefit of them using something they've created previously, but they did not create for you. Let's see. If it's work for hire, we own it. If it's not, typically the answer is we don't. Had prior to entering the contract, merely using the performance. And sometimes the issue is we don't own it, but we have rights to use it, to continue to use it, or let other people use it. So the issue is what rights are there relative to intellectual property that somehow was involved in the contract. And one of the frequent things is software. And for instance, the one example that I improperly summarized for Vital Records, where the issue was that the vendor was supposed to give a 2-year license for any software that they did not themselves own, that they brought in from another company, and provide that. And then there was an issue of whether that was something provided on the contract or not. But when you have software, do you have a license to use it? Do you own it? And even if you don't own it, do you have a license to use it? Or do you have to continue to pay each year for the license to use it? Or do you not have the right to use it? Which probably is not a good situation. If they've made it for us, or if it is a very integral aspect of something they have made for us, if they've customized something using a basic software source code, and without that source code we would have no ability to customize or modernize in the future. One of the things we typically will make sure of is that we have access to the source code. Either they have turned over the source code to us, or if it's something they claim that's their property, and we agree it's their property, we didn't pay for it, the general requirement is they place the source code in an escrow account, which means that it's a third party who does this kind of activity. They maintain escrow files, software codes for vendors under the typical situation. If a vendor goes bankrupt, if they go out of business, somebody has the source code, and usually the wording is such that if the vendor goes out of business, that source code is immediately available to any customer of that vendor to get the source code and to use. And there may be other circumstances where if there's an impasse between, excuse me, between us and a vendor, sometimes we will have the access to the source code so we can go and do things to keep our system current. So that's important. Intellectual property. Now here's a nice little example. Food service contract at a state facility, and this was the Walter P. Carter Center. Many of the residents were on special diets, which means it was low fat, low sugar, reduced calorie, puree, which means like a liquid consistency, or they had no gluten. Whatever the situation was, there were, many of the residents had some kind of dietary restriction. And so if they have dietary restrictions, then the food service vendor that is feeding them is supposed to know what the restrictions are, and they're supposed to make sure those restrictions are met, that a vendor doesn't get, a client isn't fed something they're not supposed to, and is fed something they are supposed to be fed. These diets were created based upon the collaboration of the contractor's registered dietitian and the facility medical staff. It was crucial that these diets be transferred from the outgoing contractor to the incoming one so that residents could continue with their essential diets. You need to keep feeding them what you're supposed to feed them and not give them things you're not supposed to give them just because the contractor changes. And here was a situation where the one vendor did not win the contract for the follow-up contract. And so there was going to be a transition from one vendor to another one. And actually, this was a vendor, the one who didn't win filed a protest, went to the Board of Contract Appeals. So this was one of my 13 situations where I had the privilege of going to the Board of Contract Appeals to defend the non-selection of the incumbent vendor. And we won at the Board of Contract Appeals. And not that I am alleging that there was a cause-effect relationship here, but they lost. We're ready to go to the transition, and the transition was supposed to be as of 5 or 6 o'clock on a Monday morning. Yes?
When the documents, specialized information documents, were not provided to the state, who are, the people who gave
Right.
them the contract, they should have a copy of it, right?
Well, we learned from this example that yes, we should have.
Okay, so is that in
There's always a reason why you learn something. Most of this stuff is not intuitive. It's not something that, yep, that's what we're supposed to do, because a lot of these things you just assume it's going to happen until the first time it doesn't happen. And then you realize, now we have to say this specifically. And as we're going to say here, this was the one trigger of what we learned to do with this special diets. All right, so what was not known was that over the weekend, on Saturday morning or something like that, the outgoing vendor threw all the diets and all the files and everything in the trash. It got hauled away. It wasn't there. So come Monday morning at 5 o'clock or whenever the new vendor is fully taking over and is supposed to start cooking breakfast, the new vendor starts looking for the special diets, and there's nothing there. And so then a panic call was made to the outgoing contractor of where's the special diets, and the answer was, we threw them away. And so what had to happen then is a crisis situation that on an emergency basis, that both the incoming contractor and in particular the medical staff of the Carter Center had to get together to recreate all the special diets. They had to go through the medical files to find out what each resident was supposed to have or not have, and the medical people would identify this to the contractor, the new contractor, and then the new contractor had to translate that into a dietary requirement. And so it took them, I think, like a day and a half, something like that, but working on an emergency basis, a lot of people with a lot of effort for something that no one, at least on the state's part, thought we'd even have to get into or even have to mention, because it just seemed like that's almost the equivalent of medical malpractice if it'd be one doctor to another. So they did this as soon as possible, so they got the diets recreated so the clients were not harmed in the interim. So let's see. So on the value of the extra work by both the incoming vendor, because the incoming vendor didn't expect to have to do this. That was not part of their price. Yet they did it, and now they want to get paid by the state because they didn't cause this. Plus the fact we had to pay the medical people. If they were our own staff, we paid them extra salary. If they were contracted staff, which a lot of them were, we're paying extra money under that contract. So this is another instance of actual damages, in this case amounting to several $1,000s, that we deducted from the final payment to the outgoing contractor. It's like, you shouldn't have done this. It's like, you never said a word, you never asked a question, and we wouldn't even have thought you'd have thought to do this. So we're going to deduct the money. And the outgoing vendor said, it's ours. We created it. It's in our files. We threw our files away. You don't have a right to this. There's nothing in the contract that says you have the right to this. We still deducted money because we said, we don't accept that is something. The normal practice is that is something transferred from one vendor to another, and even though there wasn't a contract requirement, we're still going to deduct the money. If you don't like it, file a claim. Let's see. They objected, and they did file a claim. When we refused to pay the amount, we denied the claim, and they never appealed that to the Board of Contract Appeals. So rightly or wrongly, well, rightly from our standpoint, they never went to the Board of Contract Appeals to challenge our denial. But they still didn't like it, they grumbled, they did more than grumble. Let's see. The claim also included objections to the facility withholding final payment until final contract reports, inventory, etc. were provided, because these were other things that were required. You have to give a final report of, and I'm not sure what was in it, but within so many days, supposedly either after the contract was over or before the contract was over, they had to give a closeout report that was in the specifications from the very beginning that would summarize what they've done and recommendations. So we said, you need to give us that. Inventory, that there were things that they were supposed to cooperate to make sure that they didn't take off with the pots and the pans and the food and stuff of that, things of that nature, and they still had not cooperated for inventory. And so what we did was, aside from deducting the money for the special diets, we said, until you give us this, until you give us the inventory, until you give us everything that we had specified in the contract that was to be provided at closeout, we're not going to pay you the final amount we owe you. And when we get these things, we'll pay after we deduct for the special diets and anything else that isn't what it should be. And a portion of the withheld monies was paid when the actions were done. And I say a portion because the actual damages, the ones for the special diets, we never paid them that because that was damages. But once they did the other things, we paid them the money. And they never tried to get one of our contracts again, which we were not unhappy about. Let's see, to prevent this type of situation in the future. So here's the issue of, you encounter a problem, what do you do about the problem? So to prevent this type of situation in the future, the contract that just started with the vendor that had to go through all the hassle of trying to recreate and realizing what a difficulty it was, they were very agreeable to doing a contract modification right then, immediately. That was a no-cost modification that specifically said diet information was state property, so there would be no issue of this nature in the future, and current copy be in the possession of the state personnel at all times, which is what you said. So not only do we own it, but you don't just simply have it in your possession, you will give us a copy of it, you will keep that copy updated so that if somehow you don't abide by the provision, we still have the information that we can give the new contractor without going through this hassle a second time. And for future procurements, the requirement was included in the specifications. That's the typical way a lot of things get in contracts after something has happened. And as I said over and over, an expert is someone who's made all the mistakes, and as I said many times, over 30 years, I can't count the number of mistakes I've made. And I keep making them. One of these days I might learn.
They're all new ones, though.
Hopefully they're new ones. That's my biggest hope. All right, so that's intellectual property, and that's just an example of one situation that happened about that one, and not something that people would traditionally think of as intellectual property. Physical property. If a vendor has been using state property such as furniture and equipment, or has been operating a facility such as a kitchen, where did I think of that one? All property needs to be returned to the state or turned over to a successor contractor as of the end of the current contract. An inventory must be taken of such property at the end of the contract to determine what is actually being turned over, i.e. has a lot of stuff disappeared over the years? Have we given them not only pots and pans and utensils and dishes, and but food and stuff of that nature that we have paid for, and lo and behold, when it goes to the new contractor, half of it isn't there. So if we have specified what the proper level of inventory is, they have to turn over the same level as they received to begin with. If they don't, one of two things has to happen. Either they have to go out and buy the equipment to make up for what should be there, or the amount is deducted from them so that the state can buy it to have it for the new vendor. Let's see, if there will not be a successor contractor, the inventory should be jointly taken by the state and the contractor. Jointly taken by the state and the contractor. So it isn't just that they say, yes, everything is there, and we're taking their word for it. We have to be there with them so that we're validating If they say it's there, we see that it's there. And if they say it's there and we don't see that it's there, we don't accept them saying it's there. We will say, no, it's not here. And if they say, well, this is it, we're saying there's no way that's the object in question. That isn't it, or something of that nature. So that makes it honest if you have that two-way match. If there's going to be a new contractor, a successor, then you have a three-way match, jointly between the state, the outgoing contractor, and the incoming contractor. So all are satisfied with the accuracy. So we know what's being turned over from one vendor to the other. So now we know this new contractor has gotten everything they were supposed to. So when it comes into their contract, they can't claim, well, we never had that to begin with. So no, we don't owe you anything because I don't know what happened, but we never got it. You have the inventory. All parties will validate the appropriateness of it. All parties will sign to it so that that can be used in the future to say, yes, it was turned over. It was here. So you have to pay for it, make up for it, whatever it is, it was there. Any shortages need to be accounted for. The vendor is responsible to maintain the inventory and document situations such as authorized disposal. Lots of times equipment becomes obsolete. If that happens, there should be specifications similar to what we have with the state disposal property, that there is approval to get rid of something, and that way it comes off the inventory, so when you do it again, you're not looking for something that's been disposed of. Conversely, if that hasn't happened, and you get to the end, and you're doing the inventory, and one or more pieces of equipment or furniture aren't there, and the vendor says, oh, that stuff broke, I threw it out, and then you go, well, where was the approval? Well, we didn't think we needed approval. We never asked you for it. If the procedure is that they can't dispose of anything that they didn't get approval, it's not there, you're going to deduct the fact that it's not there, and even if it was broken, they didn't get proper approval to evidence it was broken, and so you still charge them for it. Let's see. Damage, sometimes our clients are the ones that damage something. Sometimes state employees damage something, sometimes visitors. So was it obsolete? Was it damaged by other than the vendor that they're not going to be held responsible? So again, either comes off of the inventory, or we authorize, we go ahead and buy the replacement ourselves and put the new items on the inventory. Theft. And again, it could be a theft for which the vendor wasn't liable, going back to that issue of the two instances we had with the security contract and the $4,000 of equipment at one time and the $9,000 another time. If it disappears, it's noted, and the question is whether it's something they're responsible for. Let's see, any unexplained shortages not properly documented as per the prior slide need to be accounted for. The outgoing contractor should be required to bring the inventory up to the required level, either bring it up to the required level without additional payment, or the state or the incoming contractor can bring the inventory up to the required level with deduction from the final payment to the actual contractor. And this is another instance of actual damages. The specifications need to be clear on exactly what property is state property versus property of the contractor that the contractor may retain when the contract ends. Because if they brought in their own computers, they brought in their own furniture, they have the right to take their equipment out. But we need to make sure which is theirs versus which is the state. That's why everything needs to be specified and clear. That we need to, this is not a situation for them to basically borrow stuff from the state that really is state property. So we need to be clear. For state-owned property, there should be a procedure specified for valuing any shortages, whether it's acquisition costs, less depreciation. That's a typical situation. If we said it should make deduction, and making a deduction is one thing, how much the deduction should be is something else. And so that should be in your specifications, how you're going to go about in doing this, so that hopefully there's no contest over coming to a value for anything that's missing. And we do have additional discussion of this in the planning class when you're talking about what to go in the specifications to begin with. Okay, anything about either intellectual property or physical property? I know these are things that everyone loves to get into. Fiscal audit. If the nature of the contract involves the contractor handling monies on behalf of or payments due to the state, such as collecting fees, making payments, paying commissions, if it's something where they owe us money in some way, usually there should be some type of a final audit or accounting that assures that we have the monies we're supposed to have. If it's we have a contractor doing the registration for the picnic grounds and the cabins and things like that for the Department of Natural Resources in the state parks. So we have a vendor that is collecting the money. Everyone that registers to use a picnic ground, a camp, a cabin, things of that nature, pays the vendor, and the vendor is supposed to pay that money to the state after receiving their fee for doing the work. We want to make sure that there is proper accounting, that monies they received supposedly on our behalf have gone to the state. So we need a final audit to make sure as much as possible that is the situation. Final vendor payment and the release of bonds should be held up until this is done for something that involves money of this nature, part of closeout. Unresolved contract claims. If the state has filed a claim against the vendor that isn't resolved as of the end of the contract, usually either don't pay until the claim is resolved. That's one alternative. Second alternative is to basically make a guess as to what the value is, deduct that potential amount of money from final payment, pay the rest, but with the caveat that if actually it turns out that not that much was due the vendor, then the vendor is still liable to pay it back, which probably should be added to that. And so you don't just pay them the money and hope to get it back later if the judgment is in our favor. All right, documentation. Has all documentation from the contractor been received? Has the contractor been reminded of its obligation to return its records, retain its records? Has the contractor provided assurance of its intent to maintain its records? And sometimes we even ask them for their plan that documents their intent and their capability and where they're going to store it and how they're going to assure access to it if necessary. That's something that we can ask. Again, we have the right, they're required by contract to retain all records for 3 years after final payment. And most vendors, well, I probably can't say that. It's easy for vendors to kind of overlook this because it's not something where it's a tangible, you need to do this in exchange for payment. They've already gotten paid, and you're not going to withhold money because of the assurance of how they're going to have access to records. So since there's not going to be payment for retainage of records, you may want some extra effort for the vendor to actually document how they're going to make sure the records are retained, so that at least they have something on paper that indicates they're aware of the requirement and they have a plan for keeping it, where they're going to keep it, how you're going to get access, things of that nature. Let's see. Transition. And again, if you have any questions, throw them out, because I know you just love for me to keep droning on and on and on, because it's such fun, both for you and for me. There should be a contract requirement for an outgoing contractor to cooperate with an incoming contractor to assure a seamless transition. Now, most of us know that if you have a contract, a service that needs to continue indefinitely, and you're going from one vendor to another, you will have at least some standard language, whether it's a couple sentences that say the current contractor must cooperate with incoming contractor. Now, you may want to go well beyond just that statement that says you will cooperate. You may want evidence. You may want a transition plan that evidence how they're going to cooperate. Let's see, and lots of times in the specifications we will have this. Often it is specified what current contractor personnel have to be involved. Your contract manager, your this manager, your this person, etc. That is who must be involved from the current contractor. When? Do you do it 2 days before the contract's over? Do you do it 2 weeks before the contract's over? 2 months? Do you start with one person at the 2-week point and you bring in 3 other people at the 1-week point so that everything is done smoothly? So if we have a reason to know what these should be, which usually is from experience in the past, put it in the specifications. So it's a contract requirement that they do this, which means it's part of, if they don't do it, they don't get paid in the final payment. What access will be provided in terms of information, physical space, procedures, protocols. Again, what is the outgoing contractor going to give to the incoming contractor? And lots of times they need to be basically on site and paralleling each other so that they're physically on site, there's constant meetings, they may begin to have access to data files, things of this nature, so that the new contractor can set up their own data system and make sure it accommodates the data in the format of the old vendor so that you have this smooth transition. So these things, major contracts with major transition, these should be specified. If an outgoing vendor does not exert necessary efforts to help with a smooth transition, an appropriate amount should be deducted from final payment. If you're going to cause impediments to the new vendor, cause the new vendor to incur more expenses that they're going to come after the state for, we're going to deduct it from the old vendor if we specified they had to do these things. If we can't make the transition because of their lack of action, again, there's going to be damages. Maybe require them to continue without further payment until they provide this and the new vendor is ready to do it without falling down on the job. The basic issue is we want it to be basically transparent to anyone but the 2 vendors involved that we have made a change from one to the other. And based upon any extra effort by either state or incoming vendor personnel due to the lack of cooperation, that wonderful thing of damages. You cause damages, you cause extra expense, we deduct it. Sometimes a fixed price for outgoing transition costs is included in the procurement. Now this is a decision that's made in the planning stage of, do we actually allow a vendor, any vendor, to quote a price for outgoing transition? That because there's some extra effort involved in them doing the closeout, it's something we may not expect them to be able to cover with their normal monthly cost over a 3-year contract or a 5-year contract. So maybe we'll say you can quote a transition in price and a transition out price. And if they quote, let's say, $5,000 for transition out, and they don't cooperate, then we already have $5,000 that we know potentially we're going to withhold for payment, maybe in its entirety, maybe partially. This is not a frequent occurrence. It is more frequent to have a fixed price for incoming transition than outgoing, but in some circumstances you may decide this is worthwhile, and if you have that in the provision and you have a price, you have something that already has a value for withholding. Yes?
What happens if the same contractor won the next contract?
Well, in that case, usually when you're addressing transition, you will have a provision as to typically if the current contractor is not awarded the successor contract. And then you're going to say either there will be some kind of a scaled down transition or maybe there'll be no transition. But frequently, so the first thing is if there is going to be a different contractor, then everything that you have in your transition planning will apply. And if it's going to be the same vendor, then you should have had something in there that talked about whether you're going to require any type of transition planning, and maybe you will have asked them to, in their proposal, identify transition and let them say, in so many words, are they going to do something different for if they get the new contract than the old contract?
I was just wondering if the same contractor gets the new job, then maybe that money that they have quoted can be deducted from them because they didn't incur that cost.
Well, typically the incoming contractor is either going to charge nothing for transition. If you allow transition in, and they're the incumbent vendor, they're either going to charge nothing or they're going to charge a very low price for transition because they still may do something. And that actually is one of the advantages of an incumbent. They've already paid for everything to get on the job, where someone else is going to have to incur those expenses. So if we specifically allow a price for transition in, we know that in most circumstances it's going to be a price advantage to an incumbent, and that's just the way it is. If someone wants to win, they know they have to quote very low, so they basically, and if I can use the terminology, buy the contract, so that they get to be the incumbent and get to enjoy the advantages. But sometimes we have substantial differences between the way one contract is to be performed versus the next one. And so even if an incumbent wins, there still may be something they have to do different than what they're doing in the current contract. They still may have some type of transition. For instance, we still, whether it's the incoming contract, the incumbent or not, we're still going to want to have a work initiation conference. We still want them to have the various plans so that any differences are accounted for by the new contractor. And sometimes that's important because you want to make sure, if there are differences, that the new contractor just doesn't, the existing contractor doesn't just continue to do everything the same as they are currently, because there's differences. You want them to acknowledge those differences, plan for them, so that you expect to get those differences. But these are things that you will typically should anticipate in the planning stage, so you have them in your specifications, and once they're in the specifications, then the issue of contract management is to make sure they're done. And if they're not done, you take effort to try to get them, or else you withhold money because they're not done. That's a very good point, and that does happen. Lots of times incumbents will win the successor contract, and lots of times we don't address what happens if the incumbent wins again. And you should, because lots of times their typical reaction is, we don't do anything different. And maybe you do want them to do something different. Let's see. Okay, anything else on transition?
Yeah.
Yes, we have
Just for a moment.
a statement from the peanut gallery.
The transition is often very difficult because we didn't plan for the transition out, and we wind up having to extend a contract to do that. And then there's an overlap, particularly an overlap of payment. It becomes even more muddled operationally when you're paying a contractor by the task, or by the piece, or by the phone call, or by the processing of a claim. How much work is the outgoing vendor going to do? Is there going to be an absolute switch thrown at some date where the new one takes over because he's been shadowing or watching the previous one? Or is there going to be some work given to the original vendor, a little bit of work to the other one, and then you start transitioning more and more? These become operational challenges, and it's not the contract monitor necessarily who's making decisions on this. It's the program people who have to work with you so that the vendors, both the incoming and outgoing, are able to coordinate their efforts. They have to have a game plan. They have to know which way they're going. And the only way you're going to really do that is by getting both vendors together with the program people and with the contract monitor. So operationally, it's a little more complicated.
Gary's talking again about major contracts, and something, taking a point for what he said, something that seemingly more frequently than it should that is overlooked is, do you need a transition time if you don't have the same contractor win the next contractor? We have had procurements that have been done, and then requests come to us to extend the existing contract for 30 days, 60 days, 90 days, because now that the same vendor didn't win again, you need a transition. And the one thing that is constant, and the one caution, is you should not be paying two vendors for the same activity. So if there's a claim processing, if that's what's involved here, only one vendor can actually process the claim. So even if you have the incoming shadowing, getting their people up to speed, getting them trained, making sure their data systems are compatible, still only one vendor is actually going to process a claim. And that should be the current contractor who's doing that. So that's why frequently if you have that situation where you have to have on-site people and on-site circumstances, that's where you might have the transition in cost that's on your price form. So the vendor, the incoming vendor is getting paid for these type of activities while it's doing things shadowing the current vendor, but only the current vendor is actually getting paid for each phone call or each claim, things of that nature. If it is something that isn't that specific, where you have deliverables that can be transitioned almost piecemeal, then you want to have a plan so that it's always known which vendor is responsible for what activity, so you know which one to pay and what rate to pay at. The old vendor's rate or the new vendor's rate. And in the planning, you will anticipate these type of issues, the time frame. And again, to your point, lots of times they talk about you have a 90-day transition period between contractors, but lots of times it also doesn't mention, do you still need 90 days if the incumbent wins? And usually the answer is no. Maybe there's a 30-day transition, usually a 2-week transition. And so what happens if it's not the incumbent, if it is the incumbent that wins? Those should be addressed in planning, and if they aren't, then usually we have these things after the fact where there are modifications being done with the current contractor for things that weren't thought of when their contract was awarded. So that's why you try to anticipate as much as possible. That's one of the reasons we have all this volumes and volumes of information to try to let you know what things you should be thinking of. You have the more difficult task of figuring out when these things apply. And when they apply, what are the details? How much time? How much expense? Do we give the startup cost? Do we not? But at least we're trying to remind you what the issues are. And transition is difficult. And the thing to keep in mind is there's 2 transitions. There's transition in and transition out. And we tend to have more focus on the transition in when the new vendor's coming in than we do on the responsibility of the outgoing vendor. And that's why, at least at some point in time, your contract, your specifications need to address both incoming and outgoing, so that when you get to the outgoing, it's now been covered for the vendor that is the one that is transitioning out. So from that point on, things are covered procurement through procurement. It can be very difficult. And the more important the service that's being delivered or the activity, the more essential it is that you don't miss a step. If you have medical services being provided to clients, well, you don't want the incoming medical provider to take a week to try to figure out what the clients need in terms of medical care, and for the week they're not getting the proper care, they're not getting proper prescriptions, things of that nature. So if it's something you cannot have a drop-off, you need to spend extra attention on transition. Okay, moving along, payments. Still on the issue of closing out the contract. Has the contractor made its payments to subcontractors? We have the prompt payment clause that's been in existence for about 2 years now, 2 to 3 years, that they are supposed to promptly pay subcontractors, and if they don't, potentially the state can come in and can get to the point even that we pay the subcontractor and deduct it from the prime. So before you make final payment, you're going to want to make sure that subcontractors are paid. If the vendor owes the state money, we have gotten our money. If the vendor is paying claims to doctors, lawyers, hospitals, anybody, that they have paid the third parties, so that after the contract is over and we supposedly have paid money, we don't have the third party coming to the state saying, wait a minute, I filed a claim, I never got paid, and the vendor say, and the state saying, well, we paid the contractor. And that doesn't make a difference if you're a doctor, you provided a service, you want to get paid for the service. You don't care whether a particular vendor was supposed to be paid to do it and that vendor didn't do it, you want your money. And so we want to make sure before we make payments, the vendor has done this part of their obligations. Yes?
What would be some of the types of payments they would have to make to the state?
To the state?
Yeah.
If, the one I said,
Yes, okay, not being in the rules and taxes.
What was that?
Tax payments.
Okay, if they owe the state taxes, we don't make final payment until they pay the tax they owed. But in the example of the registration system for the state parks, we want to make sure that if they are doing the registrations up to, let's say, December 31st, we want to make sure that any reservation that is made by December 31st, and we know what reservations were made, we know what money is supposed to be paid, and so that's part of the final audit, that we validate what they owe us that they should be turning over to us. If it's a commission-based contract, where they are doing sales and they're paying a commission to the state, we want to get the commission. We will audit to make sure what their sales are, and thus we know what they should be paying us, and we don't pay them until we get those payments to the state. So it's not a typical contract, but there are contracts that do that. So that's where we're trying to cover the gamut. Anything, to put it this way, anything I could think of, I've thrown in these slides. And I know they're not often in the most succinct order, and sometimes the redundancy, and in the future we hope to get this more polished in terms to eliminate redundancy, to make sure the flow is proper. We're going to have table of contents, we're going to have indexes, but we're getting it out to you before we get to those other niceties, so you can start hopefully benefiting from them. Let's see, state. So again, we're looking to payments, so this is where the state, focusing on what we're going to pay for. Has the state made its payments for regular deliverables, run out, and withholding and retainage? We've talked about, did we talk about retainage in this class? Because that's primarily something for the planning class. But retainage is basically if you've held 10% of what the vendor is due. At some point, if they have provided the deliverable that you are withholding money to make sure it was done, we have to pay them the retainage. Or if they've never done the deliverable, then at some point the withholding becomes a final deduction, a permanent deduction. So you're going to have to know when you're supposed to pay the withholding and whether you even should pay the withholding versus just deduct it as a damages situation. And what that gets down to is final payment. When should final payment be made? And when there is final payment, you should have appropriate deductions for anything you should deduct. The possession is 9/10 of the law. You don't want to pay the vendor and try to get money back from the vendor if later you find out you paid things that you shouldn't have. It's always best to figure out what you should pay them what you owe them, don't pay them what you don't owe them, and if they disagree with what you paid them, make them file a claim against you. That's better than us trying to get it from them. For major contracts, final payment has great significance. That means something. A vendor's acceptance, cashing of final payment, is usually construed to mean that the vendor is accepting all prior actions by the agency, including any deductions that may have been made for damages, incomplete performance, etc. Without some immediate notice to the contrary, acceptance of final payment will be used against a vendor if it subsequently files a claim about some aspect of the agency's payment under the contract. So, and I'll go to the next couple slides. Could we expand on this in the slides, and then I'll see if I need to amplify any more. So we're talking about final payment and the significance of final payment. Final payment can also be used against the state. If the state makes final payment, generally it is saying that everything the vendor has done to that point is satisfactory and conforms to contract requirements, so it may be difficult for the state to later make a claim of improper performance and seek damages from a vendor. So both parties, when there's final payment, then it becomes much more difficult to try to get something beyond that, either them get more money for us or us get more money from them, because final payment is supposed to mean this wipes the slate clean and everything is done from both parties' perspective. That's what it's supposed to mean. Because of the significance of final payment, it may be advisable to ensure that the final payment is made in a manner that ensures receipt by the vendor and an acknowledgement by the vendor that it understands this final payment is payment in full by the state for all goods, services, etc., performed under the subject contract. And often you will want specific language that goes along with that final payment. And you should go to your assistant AG. You should get them to draft that language that basically says to the vendor, by accepting this payment, I acknowledge that I am accepting this as payment in full for all services provided in this contract, and I will not seek to make further claims and to come back and claim this, claim that, claim the other thing. This is it, lock, stock, and barrel. This is what you want the vendor to sign so that, at least from their perspective, theoretically, it's over with. And if they do later come back and claim you owe them money, the first thing you're going to do is say, well, what is there about this signed acknowledgement that we shouldn't take at face value and say you acknowledge you've gotten everything you're entitled to? Why should we even consider anything more? And usually that's the end of it. And if they don't sign that, that means they're telling you right then and there they have an issue, and you're dealing with that issue then and there because they're not signing it. And sometimes you have a back and forth. Your attorney will draft the language, you'll give it to the vendor will say, and they'll start wanting to tweak it. Well, it's final payment except for the provision of this if we, within X number of days, discover such and such, and then you'll go back to your attorney and plus your contract manager and your program people. Do you want to accept that as something of a caveat, or do you want to hold firm? So at least at some point you'll get to something the vendor signs that acknowledges in some acceptable fashion that it's over. Let's see. Even though state payments are generally made electronically or at least via the U.S. mail, it may be advisable for the final payment to be excluded from this normal procedure and made via check transmitted either via certified U.S. mail with return receipt, by courier with signed evidence of delivery, in person. If you want this specific acknowledgement that this is the final payment, and if you want to make sure they have received this final payment and they're totally aware of the conditions that your lawyer has written about final payment, you may want to go to this extent to make sure the final payment is delivered in some fashion that you can validate, being able to take back this signed document that acknowledges they got it and they're acknowledging that this means everything is over. And again, the check, if it is a check that you send specifically versus electronic payment, that would have the special notice on the prior slide talking about that would be drafted by your attorney. That would be with the check. So if they cash it, this is what it means by them cashing this check, that they're acknowledging that's final payment. They will not come back and claim anything else. Any questions on final payment? And for many of you, maybe there were things involved there you never heard of or never thought of before. Because believe me, years ago, I never thought of any of this stuff. Releasing of bonds. If the state has required bonds from a vendor, when the contract ends, the vendor likely will want a written bond release signed by the procurement officer or contract manager. Vendors want releases because they have to pay for a bond as long as it's in effect. As long as a bond is in effect, the vendor has to keep paying for it. And so they will want a release of the bond as soon as they think that it is appropriate, that they've done what is called for, so they can get it released, so they can stop paying, they can be out from under the liability for the bond, things of this nature. Once there is a release signed for by the state, they can cancel the bond, which means they stop paying for the bond. And from your standpoint, before you release a bond, go to your assistant AG and make sure he or she says, okay, I agree, it's appropriate to release a bond. And I know at least one assistant attorney general whose position was, and I don't know how reasonable this is, but that a state would never release a performance bond. Because, and maybe not never, but at least not for a couple years. Because the contention was, well, everything may seem okay now, but who knows whether a year from now something's going to go wrong, and if we've released the bond and something goes wrong, then we have to file a claim against the vendor, we have to prove it, we have to try to collect it, whereas if we retain the bond and require the bond to be retained for, as a run-out provision for a year, 2 years, 3 years, something like that, the vendor's still paying for it, but we still have the protection. And the one example of that, probably other ones, but the one I specifically know about, is when the light rail was first built, that they required concrete ties, the cross sections that the rails go on to support the rails. And these concrete ties were supposed to last for 10, 15 years, something like that, before they needed to be replaced. Traditionally, ties would be wooden ties from when railroads first started in the 1800s until relatively recently. It was always this very hard wood that would be the tie. And the new requirement was you go to concrete. And whatever the life of the concrete was supposed to be, unfortunately, after about 5 years, the concrete started deteriorating much sooner than it ever was supposed to. And what happened was that the state, because everything was paid for, everything was accepted, all the bonds were released, the state had to pay the expense of taking up the rails, taking up the old deteriorated concrete ties, getting new concrete ties that supposedly met the specifications, and the expense of that was something like 3 times more expensive than the initial installation, because now it's not just putting something down, but it's suspending traffic, and while you have the rails torn up, you have to have buses transporting people, taking up the rails, bringing in something else, put it down, and you have an urgency because the whole while you're diverting people from using the system. And that's kind of like an example. If you would have had the bond being in place for, if it's supposed to last for 15 years, maybe you have the bond in place for 15 years. That's why you go to your attorney to make sure that you have the proper protection.
Then the vendor could have included that cost of that 15-year bond into the...
Yes, you have to let them know when you're going to release the bond. And if we say we're not going to release it for 10 years, they have to include the cost. Now, the other aspect is it's easy for us to specify something, but if you're a surety, sureties don't want to be on the hook for 10 years. And so, on the other hand, if we specified that the bond wouldn't be released for 10 years, no vendors might be able to get a bond. So that's a dynamic that has to come into play. So that's where you specify something that has the protections for the state, and you see what I call pushback you get from the vendor. Are you getting all the vendors saying, if you require a bond that lasts for 5 years after the contract's over, I can't bid because I can't get a bond of that nature? And I've had situations where I've actually had vendors who not only said that, but they had their bonding company send me a letter directly that says, we, not only us, but we and none of our competitors will write you a bond of the nature that you're requesting. And so we're telling you right now, if you request this, we will not bond our typical customer, and we don't think any other of our competitors will do it either. And when you get something like that, then basically you either give or you don't get any responses. So that's the dynamic of you try to do the protections, and if nobody squawks, fine, you're okay. If they squawk, then you have to make a determination. Do you give? Do you give it to some degree? Just what do you do? But this is an issue, and hopefully it has been in your specifications, so this does not become an issue of dispute with your vendor. You don't ever want to get in a dispute situation. It's always going to be nasty. It's always going to take time. Yes?
If you had specified that in your RFP and found out after the fact, after you'd already posted it and everything, would you then have to do an amendment to your RFP and post that you were amending that
I don't follow.
Bond requirement? Like if you had the bond requirement in there and you said that, the sureties were calling and saying...
They'll tell you before the bid's due.
Right, but if it's already in the specifications and people aren't going to be able to get that
Then you do an amendment to your specifications.
Right, and you'd have to post that and.
Yes.
Yeah.
Amendment to the specifications has to be delivered, emailed in marketplace to all known vendors. They have to have it in time for them to consider it in their response. The issue that's more of a problem is not when it happens before the bids or proposals come in, but what happens if 3 years into it, a bonding company, let's say, potentially cancels something, which they're not supposed to be able to do, but there can always be something that arises, and then maybe you have an issue. Or if you haven't addressed it properly, and it comes to the point that the vendor comes to you and wants to release, and you say, no, I'm going to hold it for the next 2 years, you're going to have a problem with your vendor. And that's where they're probably going to file a claim against you, and you're going to have the situation of trying to defend it. So it's always best to try to address something up front so it is known, it's accounted for in the price, and so hopefully you won't have major issues. Because you don't have time to get embroiled in disputes. There's other things you're supposed to be doing.
Just one comment. There may be another way of looking at this too, and that is normally, particularly in a construction job, you're going to require the vendor to carry errors and omissions insurance. And if in the example, and I don't know the facts of the example that Joel gave with the railroad ties, the concrete ties, if indeed the state had given specifications as to how the tie was to be built, and that specification was defective, well then the onus is on the state to pay for the replacement. If, however, the contractor used improper concrete, used thinner rebar than was specified, that's the type of thing that would be, although it's a fight always with insurance companies, it would be under errors and omissions. And I believe, although I don't know the legalities of it, but I believe it covers the action that was performed at the time that the contract was in effect. So if the contract is over, but there's a problem afterwards, you would go after the insurance the company and the insurance company for a claim under the errors and omissions. But again, that's a legal thing I'm not aware of.
Yes.
Was it some type of like warranty on this piece of material?
The ties?
Yeah, that the state required that was supposed to hold up for so many years?
I don't know the details.
Okay.
So hopefully there was something, all I know is this was something that was cited as a problem, and this type of problem hopefully would be avoided in the future. Excuse me. So hopefully we had all kinds of assurance and things like that, but what I was told was, in this instance, for whatever reason, and maybe it was the fact that we gave faulty specifications, I don't know, but the state ended up having to lay out a substantial amount of money to do this replacement. And maybe we laid it out initially and then tried to sue the vendor, I'm not sure. But something wasn't there that we readily could collect on.
But could the state ask for some type of warranty, or maybe it specified a particular material?
We could ask for a warranty, and that's where, as Gary has said, we will either have a bond that exists for a certain duration, or insurance, or something. And it can get as, well, I can say this, you can even have, to the point of you can have like a monetary fund that the vendor might pay into that you retain, which probably isn't feasible, but there's things that you should try to do to make sure these are in place. And at the very least, we always have the ability, if we don't have the protection that runs for, let's say, 10 years, then we always have the ability to file a claim, file a suit against them. That happens all the time, where there's suits filed against companies years after the fact because it wasn't known until at that point that there was a problem. Excuse me. The bridge over the Mississippi River between Minneapolis and St. Paul about 5 years ago that collapsed, Interstate 35, and I think 11 people died. And what they found after they did the investigation, the vendor simply didn't follow the blueprints. They used substandard materials, didn't put the things together properly, and until the bridge collapsed, which I don't know whether it was 10, 12, 15 years, I don't know how long it would have been in place, but until it collapsed, it wasn't known that the vendor hadn't done this. And I don't know whether there was improper inspection at the time or whether even inspection wouldn't have identified that. But whatever the situation, once the collapse happened, then you go back and you figure out, is it the architect that designed it? Is the contractor that did it? Just who was responsible, and then you sue them. And that's an example of, even if you had no bond or no insurance, you still can sue them and try and get actual damages. But that involved the lawsuit and the lengthy period of time and things of this nature. So let me just finish this, and then it'll be break time. The timing of the release of bonds can be a point of contention between the vendor and the state. The state should resist releasing a bond until it is clear the protection afforded by the bond is no longer needed. Excuse me. For fidelity and payment bonds, 1 to 2 months may be sufficient time to ensure there are no outstanding issues of theft or non-payment of vendor employees or subcontractors. Fidelity bond is what's called an honesty bond. That means that the vendor is going to pay the state money it owes. Payment means subcontractors, employees, etc. have gotten paid. For performance bonds, it may be months or even years before it can be reasonably assured that there are no latent problems with the contractor's work. So it can become an issue. With that, take a break.